Here's a great question and one that really needs to be addressed. It's from a gentleman. I don't want to say his name because it might give it away. It's a very unique name. Will the short sale stop the bank from foreclosing on my home?
No. No.
Wait, can you elaborate on that?
No.
Live television, folks.
They need to hear that answer. The answer is no. It's a big emphatic no. And this is a misconception. The bank will not start.
It is. A lot of people think that, oh, I know one hand's dealing with the other, right?
Right.
Not true.
Right.
Okay,
no,
I'm sorry.
No. The right hand and the left hand, they never talk to each other. Not to digress a little bit, but I've had short sale closings, and then my clients were served a few days after the closing occurred, and that is a result of the bank doesn't talk to their attorneys, and it's just a huge mess. But okay, go back to the question.
The question was, will the short sale stop the bank from foreclosing on my home?
And the answer is no. Here's how it works. In order to go through a short sale, you do not have to stop paying. People will tell you that. You will read that on the internet. But I have had short sales where my clients have been current the entire time. And that protects you from receiving those 30, 60, 90, 120-day derogatory marks on your credit. So once you get to a place where you find you can no longer afford to make those payments, or if you're in a situation where the investor or servicer of your loan requires you to stop paying, from the first time you default, it's been my experience that you will then receive foreclosure proceeding documents within 3 to 4 months from that time period. Now, here's the goal. We have a short sale and we have foreclosure. We always want to try to start the short sale first, and then they race, okay? But what happens is when you're served with foreclosure documents, we have litigation attorneys in our firm who will assist you in representing you through that foreclosure process. I'm a real estate attorney. I'm a transactional attorney. I don't go to court. I don't monitor foreclosure cases. I don't monitor filings or anything like that. So what we do is we bring in a litigation attorney who can help through the foreclosure process. But the ultimate goal is we try to get the short sale to close before the foreclosure catches up, period. That being the case, while the short sale is going, the foreclosure can proceed along and proceed along. But just because you have let your lien holder know that you're going through a short sale and that you're trying this loss mitigation option, they don't care. And the reason they don't care is because you have entered into a loan with a lender, and there are terms and conditions in those loan documents that talk about what happens in the event you default. And in the event you default, they have the ability to sue you for foreclosure. By suing you for foreclosure, the objective is they'll try to take title back from you of the property, and then they'll try to sell that property to get any money that they can to try to credit towards the amount of money that you owe them. The banks don't have to talk to you. They don't have to talk to you at all about these loss mitigation options. And therefore, the banks are taking the perspective of, fine, we have to do this short sale thing because there's a mess with the economy now. But we know that we have a legal right to start foreclosure proceedings in the event the borrower's default. And they're going to do that. So that's a real long answer to your question, but the answer is absolutely no. If you default, you will be served with foreclosure proceedings.
Sooner or later.
Absolutely.